Very good morning, friends. Welcome on behalf of the Global Institute of Medico-legal Society for yet another knowledge share. Every session when I take, I really feel proud. I can see a large number can be a future medico-legal consultant protecting our doctors and the patients for all sort of qualified practice. We were seeing the regulation 2002 plays a vital role, as I said, because medical council governs the registration of a doctor. And medical council has got all the power to regulate doctors in this country that is given under the Act. And medical council can, for the purpose of the same, punish a doctor for violation of rules, regulations, which they define. This is the factual position of medical councils been empowered by the law of the land. And as I said, the Constitution very clearly said that health sector comes under the concurrent list. And that the reason every state has got power to make a rules and regulation for regulating doctors in their state. Center also can make a law in respect to the health sector, but then opportunity is given to state to adopt by any modification or as it is. I'll give a two example to make you understand. The center has passed Clinical Establishment Act in 2005, amended in 2010. We are in 2023, post 18 years also. Many states has not yet adopted that law, including the state of Maharashtra. And majority of states, with some modification, definitely have adopted and it has been governed. And union territory, of course, it is bound. In the same domain, another example is of Maharashtra state, like many other states also in the country, who by notification, who by GR, who by amending their act has allowed allopathic practice, which is known as modern medicine practice, to BMS and BUMS doctor registered under Schedule A, Schedule A1, B and D. The state of Maharashtra very categorically have already allowed them. Not only that, we have recently found that old CCIM, now NCIM, National Council of Indian Medicine, has brought a notification allowing 58 surgeries can be done by MS surgeon of Ayurveda. So since health sector comes under the domain of the state has got all the power to regulate their people, make the rules regulation, and control these practices. And that's the reason every state medical council has got their own act. MCI, now NMC, has got their own act, and every state, like Maharashtra has got Maharashtra's Medical Council Act, Karnataka Medical Council Act, Jammu Kashmir Medical Council Act. So every state has got their own act which regulate their doctor practicing under their states. Many other time question definitely comes, can I practice in two territories? Like border territories, many of doctors are practicing. I'll give example of Delhi and Haryana, or Delhi and Uttar Pradesh. Let it be Noida or could be Gurgaon. So hardly differences there between two states, border difference. So many of the doctors do practice here and there also. The question definitely comes, can they practice? MCI, old under the section 27, has very categorically said that people who are registered with center are allowed to practice anywhere in the country. New NMC Act, if you read, The new NMC Act very clearly says that all the doctors who are registered under NMC, now new notification came which everyone knows, where unique ID was given and now planned to give to every doctor. You need to register with new regulation. You'll get a new ID. In that notification also they specifically mentioned that all the doctors registered under national registry will be allowed to practice across the country. This is generalized, but the conflict definitely comes in various states because every state wanted that if all doctor want to practice in our state, they need to register in our state. In such a scenario, my friend, dual registration, intimation of registration must be done. Whenever any client of yours asks for such a queries or such a support system from your side, always recommend him to apply to the both the state. At least intimate to the particular state that these are the places where I am practicing. That is for safeguard. Otherwise, when the question comes for defense, always remember central act prevails over the state act. Central has superiority. When center has said that all India practice is allowed, tomorrow you can defend your doctor very well in a domain of practicing anywhere in the country. In the same ground, lots of changes has been brought by various councils during the practice. The process and procedure is variably found in our country. Every state has got their own style of inquiring if at all any contact comes. But there is specific rules for all these things. And the new NMC regulation was enacted on 2nd August 2023, which was suspended again on 23rd August 2023. And Regulation 2002 was reinstated because there is going to be amendment soon be a part to that regulation because lots of hue and cry happened because of the generic drug prescription, because of the direct, indirect sponsorship of pharma company, which made an hue and cry in the country. Pharma lobby definitely was impacted. So naturally, pharma lobby has acted on that. Association has acted on that and that will suspend. We will definitely look to that act when it comes. As on today, since Regulation 2002 is the act which is been governing medical practice, we will going to speak on that and we will understand that. But yes, NMC Regulation 2023 has already adopted 80% or more of the part of Regulation 2002. Almost everything is adopted. Newer things which we have find in NMC, we need to, will definitely know that newer things which comes and whenever it get amended. 11 types of punishment has been found in new NMC Regulation 2023. Guidelines are very specifically given for social media, for telemedicine, for online prescription, the consent. Everything has been well clearly defined under the NMC Act and Regulation 2023. But it need to be taken again when amendment comes. But yes, let me share to all my colleagues here that regulations are going to be little strict. Newer laws are coming in our country when I talk about medical practice. Not only the NMC regulation 23, which is tightening our medical practice for everything, but also the Consumer Protection Act 2019, which we have seen that have really cornered doctors in medical negligence. And the most worry point, my friend, the new law of criminality, which soon are going to come in a country where IPC is going to be repealed, CRPC is going to be repealed, Evidence Act is going to be repealed, and because these are the British Times Act, like 1860, IPC was formed, then 1972 naturally needed amendment where Evidence Act came in. So naturally, lots of amendment needed. The government are planned to come out with three major acts in criminality, which was on to standing committee. Probably in next session, we will see this act. Government is very much inclined. But worry point why I said to all my doctors because the 304A, which was attracting 2 years punishment up to 2 years punishment. Till date, I've found that it has been increased to 7 years. I don't know because I've not gone to complete act, but a glimpse which I have seen. Let that act come. Let it how it comes, with what modification it comes, what Parliament has thought about regulating the criminality will be seen when this act comes. My friend, till the time we need to be really prepared for all this, as medical practitioners are being observed very keenly by antisocial activists and extortionists. And for the purpose of the same, medico-legal consultant become very important. Few people are with really a strength to the doctors and a patient at any given time. Choice is yours, whatever you want. And for the purpose of the same, it is very essential and important to understand the law in a better way. So let understand the main chapter of MCI regulated Regulation 2002 of Ethics and Ethics, which still has got a very good value, which already defined everything under them, including generic, including other things and all. Let's see, because those days also amendment was done in MCI where they talked about generic drug, but they used shall word that doctor shall prescribe, which got transformed to must word that they must prescribe. So must become mandatory. Shall has gone given us some ground to the doctor. So generic drug was also amended in 2002 regulation. Pharma relation was also regulated under 2002 regulation, where they very categorically said that pharma relation with the doctor need to be observed keenly, and they allowed a gift of 1,000 rupees. But more than 1,000 rupees, they have kept the riders and the punishment when there is a pharma and doctor nexus. Only loopholes they have given is in medical research program with the riders, with the conditions in that. But now the new law is more stricter and all the loopholes was packed. So we need to wait for NMC regulation 2023, how and what way it comes to us. So